We're on the docket in 22-02508, people of the state of Michigan versus Angela Abbott Stewart. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Miss Abbott Stewart.
And ma'am, you are Angela Abbott Stewart?
Yes, Your Honor.
Okay, and you can hear me all right, Ms. Stewart?
Yes, Your Honor.
All right. This is the time set for preliminary examination. How are we proceeding today?
Your Honor, we've reached an agreement where Miss Abbott Stewart will plead to an added count of use of methamphetamine. Plea sheet has been completed and this was going to be transferred to 55th Treatment Court. I believe the court has the paperwork for the transfer.
I think we do.
Your Honor, I received the signed copy from you and I have
Okay.
sent it to Judge Buchanan for final signature
All right.
to get it transferred down there this
And
morning.
so it's going to 55th. That means that Judge Allen has to take the plea, right?
Yes.
Okay. So this will be transferred. Judge Allen at 55th for plea. And then I'll go ahead and stick the plea agreement is an added count to. Or is that an added count to or an amended count? That's an added count to. Of use of methamphetamine?
Correct, Your Honor. I can give you the back quote if
All right,
necessary.
use. For 1 year?
Yeah, 1 year under $2,000.
And what's that pack code just for?
333.7402A-A.
So my understanding, Ms. Abbott Stewart's already waived her right to a preliminary examination within 21 days. Judge Allen is going to take the plea. And so this is just adjourned for a date in front of Judge Allen.
Yes, and today is supposed to be the day.
Okay.
So she's supposed to do the plea in a couple hours in front of Judge Allen.
Oh, okay. So this is all set up today.
Yes.
Okay. All right. Is there anything else for the record in this docket 22-02508? It sounds like everything's going to be done in the next few hours.
Nothing further, Your Honor.
Anything was?
No, Your Honor.
All right. That's all for the record 22-02508. Ma'am, it sounds like you're going to be pleading in front of Judge Allen, and then that's for the case to be transferred to 55th Court, okay?
Yes, Your Honor.
All right. That's all for the record, docket 22-02508. Thank you.
And then we can move Alyssa Hill, Your Honor.
Rothstein, how are you?
Great, how you doing, Your Honor?
Good. So we're on the record in docket 22-02304, people of the state of Michigan versus Alyssa Hill. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Jeffrey Rossi on behalf of Alyssa Hill, who's not present.
All right, and this is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, the people would request a bench warrant here. And I don't believe this is an assault and crime. I believe she's got several missed court dates open, plus a bunch of files. So I don't believe a 48 hours is appropriate here.
So you don't believe the 48 hours is appropriate? Okay, and it's a prior R&O, and I'm looking to see there's at least one prior bench warrant bond forfeiture. Any comment, Mr. Rothstein?
Your Honor, I have not even spoken to my client since
Okay.
November 1st, so
All
I
right.
have no comment.
So so the court will issue a bench warrant bond forfeiture at this time, and then we'll wait to see what further events occur,
Thank
okay?
you, Your Honor.
All right, thank you. Anything else in docket 22-02304, Mr. Wisty?
No, Your Honor.
Anything else, Mr. Rothstein?
Nothing, Your
All
Honor.
right,
Approach one.
thank you.
everybody.
Right.
Your Honor, may I briefly,
I'll take what's in the order.
Okay, perfect.
Your Honor, may I briefly be excused.
You may. All right, we're on the record in docket 22-03046. People of the state of Michigan versus Dejun Richard. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Richard, who's seated to my right.
And sir, you are Dejun Richard? All right. This is time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, we'd be proceeding with the preliminary examination.
All right, are there any preliminary matters to be brought to the court's attention before we get started?
There are a couple, Your Honor. The people only have had one witness arrive today. We are going to be calling that witness, but I will be moving for a continuance after that witness has testified. I can get into the argument after the testimony.
All right, and I'll entertain any objection or comment responding to that after the first witness. Anything from the defense?
No, Your Honor, we would just ask for the sequestration rule.
Mr. Wisty, do you have any witnesses other than the witness testifying in the courtroom right now?
No, Your Honor.
All right. And I will leave it up to the lawyers to keep an eye on the gallery to make sure that nobody comes in during the testimony. Mr. Wisty, you may proceed with your first witness.
I would call Michaela Pentecost, Your Honor, and if I may be excused.
You may. Ms. Pentecost, I'm going to have you come right up here. Okay. I'm going to have you spell your first and last name for the record. You're going to have to speak up, please.
M-A-K-A-I-L-A.
Okay, M-A-K-A-I-L-A and Pentecost.
P-E-N-T-E-C-O.
Okay, I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay. Go ahead and have a seat right here, and I'm going to have you speak up as loudly as you can for recording purposes. Mr. Wisty, you may proceed.
Thank you, Your Honor. Could you state your name for the record? Do you know a
Can
man?
you speak up? I'm sorry.
Yeah, you're going to have to speak up, ma'am.
Could you state your name again? Thank you. Do you know a man by the name of Dejuan Richard? How do you know him? So who is your friend? Who is Tajane's sister? You don't know the name of her?
All right, so I'm going to have everybody speak up because we can't hear.
You don't know the name of your friend's sister?
No.
Okay, do you recognize Dajane here in the courtroom today?
Okay, is that a yes? Is that a yes or no, ma'am?
No.
No. Could something happen involving Dajane on the evening of November 3rd, 2022?
Yep, you're going to have to speak up.
I don't remember the date.
Okay.
You remember speaking to officers in November of 2022? You don't remember speaking to officers?
I still can't hear you.
I don't remember anything from that night.
All right, if you stay right at that level, you'll be good.
So if I asked you, you don't remember police, stating to the police that you had been in the apartment where Imonte and Dejan were arguing.
I was sleeping. I had the kids with me.
You're gonna have to speak up, man.
I had the kids with me.
So on this night, you had the kids with you. Police arrived.
Is that a yes? You gotta say yes.
Yes.
You recall the police arriving that evening. You recall the police arriving that evening, is that your testimony?
Is that a yes, ma'am?
Yes.
Thank you.
And did you make a statement to the police? What,
That's a yes?
I don't remember.
you're not sure if you made a statement to the police.
I was sleeping.
You remember stating to the police that you,
I'm sorry, can you repeat the answer to the last question? I just didn't hear it. I'm
I
sorry.
don't remember anything from that night.
so if there was a police report, you remember stating to them that Imonte and Dejan were arguing? Yes or no?
No.
You remember stating that Angie pointed a handgun at Imonte and said he was gonna kill her? Remember saying that you were scared by this and that you picked up one of your kids and ran outside?
No.
Your Honor, no further questions.
Cross-examination?
None, Your Honor.
May Ms. Pentecost be excused, Ms. Wisty?
Yes, Your
All
Honor.
right, this witness is excused. Any objection, Ms. Robinson?
No, Your Honor.
All right. Ms. Twisty, your next witness or argument?
I would be moving for a continuance at this time. Your
All right, and for what reason?
Your Honor, couple of things. We did not have a number of witnesses appear. The victim herself did not appear. I had been in contact with the victim's sister, Tajane, who was also subpoenaed. She did not appear here this morning. The sister had told me she was going to appear. We did also subpoena Christopher Mosley for this. He would be the one who interviewed the victim here, and I believe his statements about what she said would be admissible. Unfortunately, he is on military leave until December 14th. And lastly, I would like now to call the witness who interviewed the police officer, Tony Sina, who interviewed Ms. Pentecost, who just testified. I believe he can testify to the extrinsic statement she made and can be entered into evidence pursuant to 613 per MB. She's been called and had an opportunity to explain those statements and be subjected to cross-examination. So what we would like to do is an adjournment, ideally after December 14th, so I can get Officer Mosby here. Alternatively, sooner, I can get Officer Tony Sina and enter extrinsic evidence of the statements Ms. Pentecost made, which I believe would be sufficient.
Thank you. Any response or objection, Ms. Robinson?
Yes, Your Honor. As you're well aware, Mr. Richard has the right to have his preliminary exam within 21 days. An extended continuance beyond December 14th would definitely prejudice Mr. Richard because one, he's in custody. Two, there's the opportunity for witnesses to be in communication with each other and that sort of thing. The state clearly hasn't met their case today. They haven't met their burden. I think the proper remedy here is to dismiss, and then when the state is ready to proceed to refile, there's nothing preventing that from happening. But to keep Mr. Richard in custody for an additional almost a month, based on the fact that this officer isn't available and the rest of their victims haven't showed up even when subpoenaed to be here, I don't think is a fair result. So I think the proper remedy in this case is a dismissal, and then if the prosecution decides that at the time they would like to refile the case, they have absolutely the right to do so within the statute of limitations. But Mr. Richards shouldn't have to sit in jail until then to wait for their witnesses to get here.
Mr. Wisty?
Your Honor, unfortunately, that's when we would need Mr. Mosby for. If the court is not inclined, a lesser of adjournment, I believe we could call Tony Sena And I believe with his testimony, there'd be enough to bind over, obviously.
I guess that's my preference at this point in time. I agree with Ms. Robinson that December 14th is at least outside, outside of the date for a continuance. But if you have further witnesses, especially witnesses you've subpoenaed for today that didn't appear, let's adjourn and continue the prelim within a date before December 14th.
Judge, was, just to be clear, was the officer Cena subpoenaed for today?
To clarify the record, that officer was not. I had anticipated Ms. Pentecost would have testified. She police report.
Right.
Given her testify this morning, I now need to submit.
Okay, response, Ms. Robinson?
Yes, Your Honor. It was clear that Officer Cena was the one who interviewed this witness in this case. If he was going to bring the case, he should have subpoenaed all of his witnesses to come into court today. He didn't, and now my client is prejudiced by having to come back another day. Like I said, I think dismissal in this case and then refiling when all of his necessary witnesses are here so that we can go proceed in a timely manner in the 21 days for which Mr. Richard is entitled to have his preliminary exam run, I think is the best option.
Well, Mr. Richard started his preliminary examination within 21 days, which is what is required by law. And I'm going to adjourn this matter to a date within the December 14th in order to get additional witnesses to testify. One that was subpoenaed, and then it appears that the officer was not subpoenaed, but
Yes,
that
Your
was
Honor.
based on
Just so
notion
we're
that.
clear, the officer Mosby was subpoenaed. He's on military leave.
Right.
He's not going to be here till December.
Right.
My intent would be to subpoena Officer Cena and have him testify to what Ms. Pentecost told pursuant to 613 as extrinsic evidence. He was
Oh.
not subpoenaed.
All right, so we'll reset. So the preliminary examination was started.
Anytime you have before the 14th is next Friday, the second at
So we'll set it for December 2nd at 8:30. That will give you a week to get Mr. Sena here to testify. So then we'll continue the prelim until December 2nd. And then at that time, if we have any problem with the bind over at that time, we'll readdress any motions to dismiss. All right, so this is reset for a continuance as to December 2nd at 8:30. Anything else from the people in regards to docket 22-03046, Mr. Wisty?
No, Your Honor.
Ms. Robinson?
No, Your Honor.
All right, that's all for the record this file. We'll see everybody here next week. Ms. White, that's, you're now in the Zoom courtroom, is that correct?
Yes, I am. Thank you.
All right, thank you, ma'am. So good, let's go on the record, and this is Mr. Burleson, right?
Correct.
Okay. Let's go on the record in docket 22025557, people of the state of Michigan versus Toby Burleson. Will the parties please indicate their appearances for the record?
Jake Wisty on behalf of the people.
And Assistant Public Defender Scott Nickel, standing in for the assigned Public Defender John Abbott for Mr. Burleson.
All right. And this is the time set for, this was a control date set out in regards, and I'll tell you my understanding, Mr. Wisty, and then you can indicate. We talked about this case. This was Mr. Abbott was here along with Mr. Wisty, and this was we were transferring this case to 55th District Court, Judge Allen's court for, I believe this was sobriety court or review, or it's to be a
Yes,
part of that sobriety court. And there was some question as to the correct procedure, since we had inconsistent paths to get there.
yes.
And it appears that the preferred path at this point, not the only path, but the preferred path, is to have Mr. Burleson withdraw his plea here and then plead in front of Judge Allen, who will accept, who is the accepting court for sobriety court. Is that my understanding?
Yes, Your Honor.
Okay, Mr. Nichols?
Yes, Your Honor.
All
I
right.
think that him pleading in 55th makes the process clean.
Right, and that's my understanding. We kind of saw this coming when Mr. Burleson first entered a plea, but we weren't sure since we had some inconsistent information, and therefore, so Mr. Wisty, it's my understanding that Mr. Burleson's going to withdraw his plea today, and I'm going to accept that, and then we'll they'll move over the matter over to 55th.
Yes, Your Honor, and I do have the transfer paperwork for the court to sign, as well as to have the chief judge sign.
All right. Yeah, let's do this first. So Mr. Nichols, is it the intent for Mr. Burleson to withdraw his plea today?
Yes.
And you, Mr. Burleson, that's your intent today to withdraw your plea? Okay. You understand, we had some of these conversations last week. This is purely procedural. So this is all on the courtroom process. None of this is on you. All right. But it's my understanding that you've got your advice of rights, you heard the negotiations, and you offered a plea. You're willing to withdraw that plea today, and the court is going to accept the withdrawal of the plea so you can make the entire process in front of Judge Allen. Is that your understanding?
Yes, sure.
All right. I find the withdrawal of the plea to be knowing, voluntarily, and understandingly made. I'm going to transfer this case over to Judge Allen for sobriety court, so that'll end your tenure here in 55th, 54A District Court, and then you'll start all under Judge Allen 55th for sobriety court. Okay.
Okay.
You will have to conduct a new plea hearing in front of him. Do you understand that, sir?
Yes, sir.
All right. So if you have some papers for me to sign, Mr. Wisty, I have some, but they're copies, so I'd rather sign yours.
I think Judge Allen will sign that one.
Yes, that is my understanding. And that signs in both of these over to
All
55th.
right, so do I sign here?
Right, would send
Okay.
John will continue on the case.
Yes.
So I would sign the plea agreement over to John.
Judge Buchanan is the last person who hasn't signed it. Everybody has to sign this.
Yes.
Okay.
This is signed by everybody. So this one will be signed by Judge Buchanan. That's the last one. Do we keep that or did? Okay. And then I have these are the same ones. All right. All right. So the 3, 2, 2. So. All right. I just indicated the transfer signed by all parties and awaiting Judge Buchanan's signature. All right, so anything else on the record in docket 22025557, Mr. Whiskey?
No, Your Honor.
Anything, Mr. Nickel?
Just your honor, just to make sure, Mr. Burleson informed me that he should have a bed available in the next week or so at House of Commons. I want to make sure his bond is set so that that won't prevent him from going to rehab.
I don't, well, his bond is set right now at 4,010%. But, and I don't have jurisdiction anymore, but I will indicate that Judge Allen should be, Judge Allen should be able to, that the defendant can be released for inpatient purposes.
Yes. Just want to make sure that he can be released to go to rehab once that bed is available.
People have no objection to that.
Thank you. All right, anything else for the record on docket 22025557, Mr. Nickel?
No, your honor.
All right. Good luck, Mr. Burleson. All right. All right. In docket 22029220, that's people of the state of Michigan versus Michael Allen Miller. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Mr. Miller. I'm covering for Aaron Robinson, the attorney record at the spot.
Okay. And this is the time set for preliminary, this is the time set for twofold. This is the time set for preliminary examination and a show cause hearing on the same day because the defendant it previously failed to appear. Mr. Whiskey, how are we proceeding today?
Your Honor, the defendant is not here. I would request a bench warrant. I do not believe 48 hours is appropriate here. Even though this is not an assaulted crime, effectively, the show cause was set to give him an opportunity to turn himself in, and he's failed to do so. So that would be the people's request, Your Honor.
Mr. Starks, any comment?
Your Honor, I did try to reach out to him by phone last night. I will stick around at the building in case he shows up a little bit later. I do have a 10 o'clock sentencing in front of Judge Kennedy, but I'll hang out just in case he appears. If he does show up, I would just request at that point that would be allowed to proceed.
All right. I as long as we're here and he shows up, I don't have, but I am going to issue, I'm going to issue the defendant failed to appear, bench warrant and bond forfeiture. And then if Mr. Starks, if he shows up, we'll entertain that when it happens.
Thank you, Your Honor.
Anything else for the record? Docket 22029220, Mr. Whiskey?
No, Your Honor.
Mr. Starks?
Nothing.
All right, thank you. That's all for the record in that file. I do have, Mr. Berry, I do have your substitution of counsel, so I'll go ahead and sign that as part of this. So we're on the record in docket 22-03064. That's People of the State of Michigan versus Daly and Fields. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Morning, Your Honor, Ronald Berry, appearing with limited purpose for today, without waiving any objection to personal jurisdiction. I'm here on behalf of Davion Fields, who's in the box standing to my left.
And sir, you are Daly and Fields?
Yes, sir.
Okay. This is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, we need at least an adjournment of the preliminary examination. I believe defense counsel is going to raise some issues regarding jurisdiction. If those issues are raised, the people would appreciate an opportunity to file response briefs on that. Additionally, the people would be moving to put some sort of bond on Mr. Fields. Reason for that, as Ms. White can explain further, is that he's currently held in a juvenile facility. He is likely to be released from that facility at the time of the upcoming holiday. He has no bond in this case. He does have bond, I think, in a pending matter of $4,400. What we would like is some monetary bond placed on this case as well. It is a serious matter, and given that he's no longer going to be held in the juvenile facility, I believe the circumstances have changed that warrant a bond now being placed on this case, Your Honor.
All right, so let's do one thing at a time here. So the request is for an adjournment on the preliminary examination in order to resolve some jurisdiction issues, as I understand it. So I'll hear from Mr. Berry on that matter.
Thank you, Your Honor. Prosecutor and I have not had an opportunity to really speak in depth regarding the jurisdiction issues, just because my recent appointment on this matter. But I got quickly up to speed by Mr. Palmer on it. Don't really know that I know the prosecutor's argument, or at least understand it. It's pretty clear. MCL 712A.3, says that the offense occurring before October 1st, 2020, if during dependency of the criminal charge against an individual in any other court, meaning other than the probate court and the juvenile division family court, it says it is ascertained if during that pending of that criminal case that the individual was under 17 at the time of the commission of the offense, the other court shall transfer the case without delay, together with all papers, documents, and testimony connected with the case, to the family division of the circuit court. So I'm not sure what the issue is. I spoke to the prosecutor briefly and asked if there's a factual issue as to the date of the offense, or the date or Mr. Fields' age or date of birth. There's no factual issues. He was 16 at the time of this offense allegedly occurring in March of 2021. That was prior to October 1st, 2021. Plain reading of the statute. I was given some rationale or reasoning from Mr. Palmer as to the prosecution's argument as to why they don't like the law, but I don't know that I understand what legal argument would be made.
All right, and so and you were just appointed on this case, right?
I was.
Yeah.
I just received discovery yesterday.
Just discovery. All right, so I'm gonna allow both parties to, I'm gonna allow Mr. Wisty to brief the issue for submission concerning jurisdiction of this matter. And then Mr. Berry, you'd have the opportunity to look at it and respond, of course.
I understand. I would ask if at a bare minimum, if the oral argument can be made right now, and if that's sufficient for the court's ruling, and if the court needs briefs further than that, because the statute does says without delay. And I think this is frankly a delay tactic by the prosecution. You can state your argument orally right now, and the court can make it an opinion. This court is, smart enough to be able to do so. This is not a nuanced law.
Mr. Wisty.
Thank you, Your Honor. The law he's talking about is passed relatively recently. It's part of the raise the age legislation. What was going on is when the legislature originally moved from 17 years old being an adult to 18, they passed within that law designed to take anybody who was then 17 in adult court and bring them back down to a juvenile court. That is what I believe is the intent of the statute. The reason here Mr. Fields was charged as an adult is because jurisdictionally, the family probate juvenile court does not have jurisdiction once he's turned 18. So the situation is when he's filed charges after he's 18, there's no jurisdiction there. If you read no jurisdiction with in context with the raise the age, returning to juvenile court, Mr. Berry is referencing, that would indicate that he cannot be charged in juvenile court, but therefore must then be sent down to juvenile court once he's charged in adult court. I believe this is a novel issue, and I believe this was not the intent of how the legislature intended to make the raise the age function. I think it's just a coincidence of how they passed the law. That may be the case, but we may just have to live with that. But I would like an opportunity to brief the issue. I believe it's a novel issue. To my knowledge, there's no case law issue addressing the situation.
Frankly, Your Honor, there's nothing that's been indicated to this court as to anything that says why this court doesn't have a mandate under the statute. All he's expressed is why, you know, what could potentially happen after the fact. If this court transfers it to the family division and the family division dismisses it, that's on the family division. This is purely a personal jurisdiction issue. And the law is clearly straightforward that this court lacks the personal jurisdiction. And there's been no argument today as to how this court would have personal jurisdiction. And there's not even a bare showing of that. So to say that we want a delay to do brief the issue when there's no argument to, I mean, there's not even an argument being made that this court has the personal jurisdiction.
But I think the fact that that we have a novel issue, according to the prosecutor, so late in the game. I mean, you've been in this case one day, if that. I mean, so I would like to hear the arguments concerning this brand new law, because
It's not brand new, I believe
it's a year old.
2 years.
Yeah. So I'm going to find good cause to adjourn today's preliminary examination. I'm not going to ask the defendant to waive his right to a 21-day. That I think we'll keep that intact, and that also set a timeline for briefs to be due. So I find that there's good cause to adjourn the probable cause or preliminary examination. Preliminary examination. And we will I will give a date because I know the timeliness is an issue here. So let's get some dates for briefs to be due. Nobody's excited about doing a brief, so it's not like we're looking for more work on our plate. But I think giving a week to the prosecutor for a brief, and then 10 days in response, or like, so 10 days, so an additional, or Mr. Berry, a week. I mean, whatever works within your schedule.
That's fine.
Okay.
I work 24/7, so.
So let's do
December 2nd for prosecutors.
yeah, December 2nd for brief due, and then
December 12th for response.
let's do December 12th for response.
And December 15th.
Then we'll reset for that actually works out well. Then we'll reset the preliminary examination for December
15th at 8:30.
15th at 8:30. All right.
15th at 8:30.
15th at 8:30.
Thank you.
Okay. So that takes care of the adjournment for good cause concerning issues of jurisdiction. And then, Mr. Wisty, did you want to be heard on bond in regards to the subsequent issue?
Yes, Your Honor, we would request some sort of monetary bond be placed on this case at this time. It is a serious charge, and it is, at least remains in adult court for the time being. Mr. Fields is currently being held in a juvenile facility. Ms. White is here to answer any questions the court may have. And please correct me if I'm wrong about anything I say, Ms. White. He does have a bond, I believe, 4,010% on another felony charge. What we'd be asking for is some monetary bond on this charge due to the fact that he's no longer going to be held in the juvenile facility.
All right. Ms. White, did you want to be heard on this matter at all?
Not at this time. I would only ask that if, if Dalen is able to make bail, he does have PR bonds on 2 other adult charges, and I would ask that part of those part of those conditions that he be placed on a tether.
All right, he's, there's no tether right now, but assuming he makes bond, I'm willing to do that. I will set a monetary bond on today's date for our purposes, okay?
Your Honor.
Mr.
The court's
Barry.
gonna make that ruling without having an opportunity for me to respond?
No, I'm gonna give you the opportunity to allocute on behalf of bond. Yes.
Okay, so with that being said, then, Your Honor, hopefully you have not already predetermined you're gonna give a monetary bond. Frankly, I think the argument by the prosecution is really poor. You look at the factors in requiring a cash bond, the court would have to determine that it's necessary to assure his appearance. There's been no allegations that Mr. Fields has failed to appear to the court. I'm not saying he hasn't. I don't know if it hasn't been brought to my attention. And so, cash bond does nothing but to go to the reassertion for safety of the community. So the fact that someone may be charged with something or the offense itself may be a severe offense, there's no bearing on the cash bond. It has conditions on, that goes towards the conditions of the bond. A tether is sufficient to address the concerns for the community. Cash bond goes to poverty and someone's debtor scale, essentially whether someone can afford to pay to get out. So without any claims that Mr. Fields had failed to come to court or he has some kind of assurance he's going to come to court, there's nothing warning a cash bond.
Thank you. Mr. Wisty, response?
Your Honor, again, this is a serious charge. I understand it's missed some juvenile arrangement. I would at least request a tether be added on this circumstance.
Okay. I'm not gonna treat Mr. Fields any different in regards to, there is somewhat, and I won't get into it, a criminal history in this matter, other than the current files, and I'll indicate for the record, which are a 10-year, a 5-year, and a 5-year. So I'm not gonna treat this matter any differently than I do any other case. So I'm gonna set bond at $4,000, 10%. With tether.
And that's
So
based upon the nature of the charge, not the factors in regarding Mr. Fields himself. Your
it's the nature of the charge and the criminal history concerning some of the matters that I don't want to get into concerning his juvenile adjudications.
Honor.
And I'm not familiar with the FTA status on those cases. But there's not a few of them. Okay. There's somewhat a criminal history here. So and I will also set that if the defendant is able to make bond, that GPS is to be ordered. And that certainly is for the protection of the community.
And I will just indicate to the court, Your Honor, that he has another file in juvenile division that there's bond conditions to that, which are Mr. Fields advised me he's going to have a tether in that one.
Okay, so
that
these,
to be coordinated through.
right,
that case.
so these would be coordinated with a current file. All right, anything else for the record, Mr. Whiskey and docket 2203064?
No, Your Honor.
Anything, Mr. Barry?
No, Your Honor, thank you.
All right, so Mr. Fields, we'll see you back here on December 15th, okay? I'll sign the order of substitution of a counsel. And Ms. White, thank you for your appearance today.
Thank you, Your Honor.
Thank you. All right, we're on the record in docket 22-02765. People of the state of Michigan versus Sharika Sheard. Will the parties please introduce themselves for the record?
Dick Christie on behalf of the people.
Greg Sullivan from the Office of Public Defender on behalf of Sharika Sheard, who is sitting to my right at council table. Your Honor.
Thank you, Mr. Silverthorne. And you are Sharika Sheard? All right. Time set for preliminary examination in the matter. Mr. Wisty, how are we proceeding?
Your Honor, we'll be proceeding with the examination, and the people do intend to add an additional count 3 of a felonious assault at the conclusion.
Are there any preliminary matters to be brought to the court's attention before we start the hearing?
Other than, I believe we'll have the witnesses sequestered. I would just ask them to leave the courtroom at this time.
All right. Any witnesses who are going to testify during the preliminary examination are asked to leave the courtroom. Mr. Silverthorne, do you have any questions or comments concerning the motion for sequestration?
No, I actually agree with that.
All right, and then if any witnesses come in during the pending of the preliminary examination, I'll entertain any type of instruction from counsel concerning making sure the motion for sequestration stays in place. Mr. Whitty, anything else?
No, Your Honor.
Did the people call their first witness?
Yes, Your Honor. I
Thank you
would
for calling.
call Desiree Mitchell.
All right, ma'am, I'm gonna have you come up and stand right in front of me, and please spell your first name and your last name so we get it right for the record.
Destinee, Destiny Mitchell, MITC.
Okay, you're gonna raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, Ms. Mitchell, I'm gonna have you sit in the chair right there, and please project for recording purposes. And it's Destiny?
Yep.
Okay, thank you. All right. Mr. Wisty, you may proceed.
Thank you, Your Honor. Could you state your name for the record one more time?
Destiny Mitchell.
Ms. Mitchell, do you know a woman by the name of Sharika Sheard?
Yes.
How do you know her?
We have the same baby daddy.
Well, how often would you have interactions with her?
Often. Like, at least, like, I'd say me and him been dealing with each other for about 4 years. So I would say probably have an interaction at least 3 or 4 times a year.
That's been going on for about 4 years. You
I'm
reckon-
gonna have both of you raise your voice.
Those interactions have been going on for about 3 or 4 years, you said?
Correct.
Do you recognize her here today in the courtroom?
Yeah.
Would you point her out and identify something she's wearing?
Right there in the ivory color jacket.
May the record reflect the witnesses identified the defendant?
Any objection?
No, Your Honor.
Without objection, the witnesses identified the defendant.
And did something happen between you and Ms. Sheard on October 5th, 2022?
Yes.
When did you first run into her that day?
At our children's school that morning.
What happened the morning of?
Or actually technically on Grand River. I was leaving the children's school and she was on her way to school.
What happened there?
She rolled her window down and threw a McDonald's cup of orange and put it in her.
All right, say it again.
She rolled her window down and threw a McDonald's cup of some type of orange juice at my car.
Okay.
From there, what did you do?
I turned around and followed her car and threw a can of Sprite at her car. And then I turned around and went home.
And then after you got home, did you see Miss Sheard any other time that day?
Yes, about an hour later.
And what happened then?
She pulled up to I live on the corner of Oakland, which is quite a busy street. She pulled up right in front of my house, her and her friends. They were in 2 different trucks. Her and a girl was in one, and there was another girl in another truck behind her.
And what was that corner of Okemos and
Oakland and Walnut.
Oakland and Walnut? Okay, thank you.
And I was already walking out of my door. I was already leaving out my house. I was on my way somewhere. And they were in my front yard. She was hooping and hollering and yelling, come out, let's fight. This and so I came out the house with a baseball bat.
What happened from there?
I told her to get out of my yard where I was gonna hit her with it.
What did she do in response to that?
She backed up in, she said, oh, you got a baseball bat? Hold on 1 second. And she walked to her truck and grabbed the baseball bat and the bag.
So at this point, you're both standing at your house, both of you have bats.
Yes.
And just for the record, your house, what city is that in?
Lansing, Michigan.
What county?
England.
So from there, you're at your home, you both got bats. What happens next?
So at first we're in the front yard swinging the bats at each other.
You swing them at each other?
Yes, we're swinging them at each other. Then she started walking over to my car and started banging on it with the bat. So I ran over to her car and I started banging on it with my bat.
When you were swinging them at each other, did you make contact at all?
No,
Well, how far apart were you?
it's not touching each other with the bats, but we were pretty close.
10
We were
feet,
swinging
5 feet? Can you
down,
give an
didn't think
estimate?
that much. We were within arm's reach. Her bat didn't touch me and my bat didn't physically touch her, but they were close to each other.
You were basically close enough to swing bats. You stretched it out in front of you, they barely missed each other.
Barely.
Okay. All right, so from there, then from there you said she starts hitting your car.
Yep, so she goes up to my car and she starts banging on the hood with the bat.
What did you do?
I was on my porch at the time because she also had a bag. So, and I knew what was in the bag. I mean, it was obvious. She stated it plenty of times. So I knew not to get too close to her. So when she started banging the bat against my car, I was already on my porch. So I shot off my porch.
Back up, she had a bag or she had the,
Yeah, because when she went to her car, she grabbed the bat and she grabbed the bat.
okay, and the bag, you said you knew what was in there? Because she said so.
Oh, yeah, plenty of times.
What did she say?
Oh, bitch, she had a little gun. She was gonna do this and that with the gun. She been said a few times that she got a gun. I didn't honestly believe it until I seen the bag, but okay. I mean, it was obvious. You got a little bag. It looked like it was something that you hold it in.
Okay. So what happened?
So I started banging on her car, ran off my porch. I started banging on her truck with my baseball bat. So she started running towards me. But when she's running towards me, she got the bat, but she's also trying to get that bag open the whole time. But it was like almost as if the zipper might have been jammed, or she couldn't get it open at first. She's steady trying to get in this bag, get in the bag. But she's running at me with the bat. I would run away. She chased me a little bit with the bat. We kind of were like doing cat and mouse with the bat. She'll run back to my car, bang on my car. I would run back to, I would go on to the porch, but I kept running back off the porch when she was banging on my car. Just kept hitting her car or whatever. Her car is in front of my house. It's a little distance, so it gave me a little bit of time to run and hit her car, run back to my porch. So we did that back and forth for I don't know how long.
Could the prosecutor instructed that have maybe tell a little bit in
A little
not
less
so narrative and
narrative.
not so fast.
Right, yep. So, yeah, if you could break up the test, it's a little harder to object when it's in a narrative form, so I'll have and indicate for the witness, if the prosecutor is trying to break you up, it's only so that to give the defense a chance to catch up with the testimony, okay? All right, you're doing fine, man, so.
So if you can just answer the question, then I'll ask a follow-up question. So we're at the point where both chasing each other. It's kind of a cat and mouse game in the yard. She's got a bag. Let's go from there.
So then she finally retrieved the gun out of the bag and she was like pointing it.
Okay.
She pointed at me a few times. She continued to bang on my
Okay,
car.
sorry. So she's retrieved the gun and she's pointing it at you.
Mhm.
How far away from you is she when she's pointing the
She's
gun?
in my driveway and I am in between my porch and her vehicle because I'm running back and forth. I'm running from my porch to her car.
So she's moving and she's pointing, you're moving while she's got the gun on.
Yep, I'm like right here on my porch and it's a driveway right here, which is only just about 3 feet away. And she's right here with my car and I'm running back and forth because it's a driveway on both sides of my houses.
At this point, is she pointing the gun at you?
Yeah, she's pointing at me and she's banging on my car with this hand. She's banging on my car with the bat with this hand and she's pointing the gun with this hand to back me up because I ran towards her with the bat too a few times when she was banging with on my car. A few times I ran towards her with the bat like I'm gonna hit you if you don't stop, but she was pointing a little gun at me, back me up. So yeah, that happened a few times.
When she's pointing the gun, is she tracking you with the gun as you're moving or how is that going on?
Well, she's at the front of my car, pointing the gun at me and banging with his hand on my car. I'm going from the porch to the car.
So when
So
you're
yeah, her hand
moving,
moved.
is she moving the gun along with your
Yes.
movements? From there, what happened?
At one point, I bust out some windows. So we're both, at this point, we both been about neck and neck with the windows. She done bust about I probably busted out first. So we about neck and neck with the windows though. Both our windows ended up getting busted out. Her back window, my front passenger, front driver, whatever, was cracked. So she cracked my window. Like I said, we were playing the cat and mouse game for a second while I'm running from the porch. But then she'll bang on my car and like try to chase me away with the gun from her car. I'll run back on the porch and she'll go back to my car and continue banging on it some more. So at one point I ran down there and I swung the bat and I busted her window. And she was just in the yard with the gun pointing at me like, oh, you think I won't blow you?
Okay,
Think I
so
won't
it's-
blow you?
Okay, go ahead. What did
And
she,
that's
what
when
did she
she shot
say
the
when she
gun.
stood there? When she shot the gun? When she shot the gun, how far away from you was she?
Say it again, Tim?
Just a couple feet. I
Couple
don't know
feet.
exactly how many. She was in my front yard and I was in the tree that's on the curb. I was in front of it.
And where was the gun? Was it pointed at you? How was it pointed?
Pointed right at me.
Ultimately, it missed you?
Yeah.
Where did the bullets end up hitting?
I'm not exactly sure, but yeah, they found the casing right behind the truck where I was standing.
When she fired the gun, what was going through your mind?
I didn't really think she was gonna shoot the gun, so I was like, man, she's really crazy.
Did you were scared? Did you feel threatened?
To an extent. I really didn't think it would have went that far, so yeah, it was like a game changer. I suppose.
After she fired the gun, what happened?
We continued to tear up each other's fun.
Say it again?
We continued to tear up each other's fun.
Okay.
She continued to bang on my car, and I threw a rock from my porch through her window.
Did she leave eventually?
Eventually, yeah, but she started to drive off at one point and got out her car to bang on my car some more.
So after she shot at you, she left in a vehicle, then came back and banged on your car some more.
No, she had got in her car and started. She only pulled off a few inches, like because it's two driveways in front of my house, on the alongside my house. So she was in front of one. She literally drove to the front of the other one. It was only like a few feet and got back out the car with her baseball bat to run and hit on my car some more. But she made sure she turned around and grabbed her gun first because she forgot her gun in her car. She turned around and grabbed it and then ran back to my car to bang on it some more.
No further questions, Your Honor.
Cross-examination?
Prosecution asked you at the start how often you interacted with Ms. Sheard, and you said, was that 3 or 4 times a year? Okay, but you also testified that your children go to school together, is that correct?
And have been for the last about 3 years, I would say.
Okay, and so your child and her children go to the same school?
Same classroom, yeah.
In the same classroom?
Mhm.
And don't you see each other?
Every day.
So you see each other every day?
Every
So
day.
what did you mean by that you interacted with her 3 or 4
I
times a
meant, like,
year?
actual discrepancies, like getting to it, have exchange of words. We see each other almost daily.
So you actually interact with her every day? Okay,
I would say that I see.
she's never threatened to kill you, has she? Okay, and this is over what, like 3 years? Okay.
I mean, it determines what you consider threatening. We done got into multiple fights. Multiple times. This ain't the first time.
Would it be
And I
correct
was-
that the source of those fights is a gentleman that's in the Newaygo County Jail?
Mhm.
That's Lorenzo Moore.
Say
And,
yes, Tim?
Yes.
Okay.
Okay, and 3 of her children are from him, and you have 1 child from him, is that correct? I won't go into a lot of detail because I don't know if it's relevant, but that's basically the source of the ongoing disagreement
Yes.
between the 2 of you, correct?
Yes. Definitely.
you say that there were multiple cars that pulled up in front of your house?
Yeah, it was a second truck.
A second truck, could you identify even by sight who was in that truck?
Chelsea Shannon.
Okay, Chelsea Shannon. Okay, did Miss Shannon ever get out of the truck?
Nope, but I threw a rock through her window too, so I knew it was her.
Okay, did Miss Shannon do anything threatening towards you?
Not when she approached my house, but prior to them pulling up, her and Miss Shannon was both on Facebook Live antagonizing me. Miss Shannon recorded my house after the police came. She was out, they must have drove by again because there's a live video of them recording my house. You can see me outside talking to the police.
How do you know Miss Shannon?
I don't. That's her friend.
Well, how do you know her name then?
From Facebook and from her antagonizing me due to her.
Okay, had you ever seen her face before?
Yes, I have.
Okay, and you threw a rock in her window?
Yeah, she was in my driveway with her.
But you threw a rock in her window, correct? Was there any other person in Miss Sheard's vehicle?
Yes.
Okay, do you know who that was?
No.
Okay. You had said that you knew what was in her bag, meaning Sharika Sheard's bag. How did you know that?
Because she said it multiple times that she's recently purchased for them.
Okay. Did she ever threaten you with it?
No, but I did, like I said, I've heard it multiple times. She will go live and stuff like that. And yeah, I've heard it. Plus Lorenzo had also told me so.
And this altercation this time wound up with both of you with bats in your hands, at some point banging on each other's vehicles, correct? I think you indicated that you banged on her windows first. Is that correct? And then she retaliated with a bat banging on yours or banging on your vehicle, correct?
Yes, when you're at my house,
Okay.
it started with the actual throw of the juice.
And at any time when this banging and windows was going on, she didn't threaten you at that time, did she? She didn't say anything threatening to you at that time, did she?
No, she pointed the gun and shot it at me when I was banging at the window.
And you continued banging on the windows after she shot at you, correct?
No, I run back to it. You see me in the video, I run back to it before.
Okay.
When it initially first
Didn't you
happened,
testify that after the shooting, this banging on the vehicles
I was just
continued?
getting to that because originally.
Okay,
when-
ma'am, that's fine. There'll be an opportunity for Mr. Wisty, the prosecutor, to explain. That even after you got shot at, the two of you continued banging with the bats, is that correct?
At a point we did.
Okay, all right. And you had said that Ms. Sheard pointed the gun right at you? And I would guess I'm about 10 feet from you. How close was Ms. Sheard?
If you're about 10 feet, I would say, take maybe like a step or two back is about how far she was. She was standing in the middle of my front yard and her car was parked directly in front of my house and I was behind it. So I would say maybe about, if you took a step back, that's about how far she was from me.
We took a step back. I've left the record, if I'm taking a single
It's
step
really
back.
just the curb, the sidewalk, and just like 2 steps and she's in my front
So
yard.
maybe 11 or 12 feet. Okay. Did she point the gun right at you or did she point it at the ground?
Her hand went up like this. Her hand, she's standing in the middle of my yard. And this is my house facing this way. And she's standing in the middle of my yard. She was turned like this. And I was standing right here at the end of her truck. You tell me what she was pointing at.
Your Honor, if you could put something on the record explaining that point like this with that. was referring.
My understanding for the record is that she was standing in the yard and she used her hands in order to be descriptive in regards to where each individual was standing. I think the 12 feet is accurate in regards to a description of where Mr. Silverthorne is in regards to the witness. And then she was using her hands to indicate where each individual was in regards to each other and the yard.
Your Honor, if I may, I believe she was pointing in the direction of Mr. Silverson, which would be the implication that that's how the defendant was pointing at her.
Correct. She did raise her hand and and indicated she was pointing the gun at face level, at shoulder level, I would say. And that was made at Mr. Silverthorne.
Some people that have been shot at indicate that they feel bullets whiz by them. Did you report that that occurred? Okay, you didn't feel any bullets go by. And again, ask you, is it possible that they were just fired into the ground?
I don't think she was firing at the ground. Her hand was clearly up, so.
Well, you
we were
can
firing
see- you
down
can
and
see her.
down. If firing down, I'm gonna fire down like this. I'm not gonna be pointing like this.
Let the record reflect, once again, she pointed her outstretched
Directly
arm
you,
at
and
Mr.
you're the person I'm
Silverthorne.
trying to hit.
And so you thought she was trying to hit you,
Yes.
and you didn't retreat at that point, correct?
When shit first happened, I ran back on my porch. But then she ran back to my car and started banging on my car again. So I want to say after that, I shot off the porch and I swung the bat at her back window and it actually busted to the side window. When it busted first. But then, yeah, I still ran back down there. I ran to my porch initially, but then I still at some point ran back off my porch and hit her car. Yes, I did.
And she still had the firearm in her hand, correct?
It never left it.
Okay, and she would have still been within 10 to 12 feet or closer to you at that
Back
time,
in my driveway.
while you were banging on her.
When I ran off my porch, she was banging on my car. That's why I ran off my porch.
And you didn't report that she shot again, is that correct?
No, I think it was just one shot. But I mean, don't quote me if I'm not actually sure. There's a lot
And
going on.
at one point, you ran back to your porch, correct?
Mhm.
But then you ran back to the location
Right.
where the vehicles were, which would be close to her, correct? With her gun, and she didn't shoot at you again, did she? And during none of this time, did she say that she wanted to kill you or anything, did she?
I don't know what she was saying. I'm yelling and she's yelling. At no time was I sitting there listening to what was coming out of her mouth word for word. I couldn't tell you what she was saying. She was yelling and I was yelling.
You don't recall any of the conversation of what you were
I
saying?
couldn't tell you what she was saying. I was saying she put the gun down and we can just fight. That's what I was saying. But we don't have to use weapons. You can just put it down and we can just do this old fashioned way. That's what I was saying.
And you were telling this while she had a gun in her hand, correct?
Yes.
Thank you, ma'am.
Redirect.
Yes, Your Honor. Ms. Mitchell, you testified that as today you remember just one shot, is that correct? You recall giving a statement to the police officers the day this happened? May I approach Your
You
Honor?
may.
I'm going to hand you a document. If you could just briefly read what that is and tell me if that looks like it's a statement you made that day. And then just yes or no.
The only thing that I don't see that's correct.
Okay, just, okay.
That was, it's because they got a couple, one, I didn't write a statement. So
So
I
I
didn't write
guess-
this for one, and for two.
Just name, I'm gonna ask you this question now. But after reading that, does that refresh your memory at all about the situation? I guess if you could read that, what I'm gonna be doing is asking you if that refreshes your memory, and some questions specifically about, well, I'll ask you the question. after you refresh your memory. And then
It's two things that's not right. You want me to tell you what they are?
Now we start, what's not right about that statement?
What's not, it says that,
Your Honor, I know that typically refreshment would be reading it and then seeing if you recall. If you're reading it and trying to edit it live, that's really not refreshment.
I'll withdraw. the
And it's
question.
not done appropriately. Either she remembers, she doesn't. She could just say, after reading it, she doesn't recall.
Okay, I agree, and the
I
objection
mean, I wouldn't
sustained.
necessarily say I wouldn't recall, I'm just saying, I didn't write this, somebody else did,
Right.
and they got a couple things.
So ma'am,
Right, so I guess I have a question about if that refreshes your memory. I'm gonna ask you a specific question whether or not it does. If it doesn't refresh your memory, it doesn't refresh your memory. Understood?
So you can take the document back.
And my specific question was after reading that statement, my understanding is you don't believe that to be 100% accurate. Does that refresh your memory when you read that? Does it take you back to that moment? You meant- So like that, after reading that statement, you still believe there was only one shot that was fired?
Yeah, she fired one. She pointed it multiple times, but she only fired one shot.
Well, that was my only question regarding that. I have no further questions, Your Honor.
Thank you. Mr. Silverthorne, may this witness be excused?
Yes, Your Honor, thank you.
Okay, Mr. Wisty?
Thank you, Your Honor. I would be calling,
All right, ma'am, you're excused.
I would be calling Jonathan Mitchell if I may be excused.
All right. Okay, Mr. Mitchell, I'm gonna have you stand right here. I'm gonna pull your mask down so we can hear you. Okay, please state your name and spell your last name for the record and spell both names. Okay, Jonathan and then Mitchell. Okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right, Mr. Mitchell, I'm gonna have you sit right here and I'm gonna have you project as loud as you can for purposes of recording, okay? Say it again. He'll tell you, he'll do the direct, but just go ahead and talk as loud as you can, okay, sir? All right, thank you. You may proceed, Mr. Wisty.
Thank you, Your Honor. Could you state your name one more time for the record? And who is Destiny Mitchell to you? Where does she live? Could you speak up a little?
Yeah, we're gonna have you speak up as loudly as you can for recording.
Oakland Street. You at her home on October 5th, 2022. Yes. When you were there, did you see a woman named Sharika Sherd come?
Is that a yes?
Yes or no?
Okay.
You recognize Ms. Sherd here in the courtroom today?
Is that a yes? So you say yes, please. Okay, thank you.
So they're recording, so they need to say yes or no. They can't type up the odds. Makes sense. So could you point out where you see her? Could you identify something she's wearing? Could you describe her just for the record so we know who's? By the face. I believe that's sufficient identification.
Any objection?
No, Your Honor.
Okay, without objection, the witnesses identify the defendant.
Thank you, Your Honor. And what did you see Ms. Sherd do that day?
Out in the house. I see my sister about to leave.
I was on the phone. She go outside. She pulled up. In the middle of the road.
And she is Miss Sherd.
Yeah, so I go outside, my sister. So I was like, go out to my sister. So my sister.
Okay,
went to jail.
I'm sorry, I gotta back you up and
I
ask
can't
you
hear.
questions.
Okay.
So let's just,
I think Mr. Bush is gonna address it.
All right, so I'm gonna have you speak as loudly as you can, because we're having trouble picking up you on the mic. And then, Mr. Whiskey will ask the questions.
so we've got to the point you saw Miss Sherd pull up at your sister's house. And at that point, you were inside the home. And then what happened from there?
I walked to the porch.
And from the porch, what did you see?
I see my sister walking up to her car, but she was walking up to my sister's car to go hit first.
Okay, so
My
when your
sister-
sister walked up to the car, can you elaborate on that?
My sister was just standing at her car talking to her.
Okay,
Like
and then-
she, like the girl, she went to my sister's car. I already went to go hit it. So my
Okay, what she
sister,
said she went to go hit it, what did she hit it with?
basically,
Did you see where she got this bat from?
I hopped out.
Okay, so you saw her hop out of the car with the bat. And after that, what's the next thing you saw her do?
She was gonna walk up on her, but she was gonna go there.
And that was, could you
All
just
right, so
speak
let-
more
I'm-
clearly? You saw your sister.
So, Mr. Whiskey, we're having trouble hearing. So if my understanding is that Ms. Sheard had a bat, and you're indicating that your sister had a bat. Is that true?
Yes.
Yes. And then Ms. Sheard went to get a gun.
Uh,
Okay, all right. Thank you. You may proceed.
Thank you, Your Honor. Did you see Ms. Sheard do anything with the gun?
I didn't want to talk.
When she fired the gun, where was she standing?
In the video, it's like my sister Flores. She was like spinning right here. They was facing each other. She was spinning and
They're facing each other. I guess a couple of things. You mentioned a video. What video are you referring to?
on video.
Who took the video? So you took the video. Did you see the things going on at the same time you're taking the video?
Yeah, I was looking at my phone. I was putting up.
So the things on the video would also be things you saw personally.
And it was different. I was on the phone. Like I was on the phone and it happened, so you can't get no idea on it.
I just wanted to clarify what the video is. It's not in evidence right now. So you see her about how far away from her sister? 5 or 6 feet. And at that point, is she pointing the gun at your sister? Is the gun at her side? Where's the gun?
It's pointing at my sister.
What part of her body was it pointed at?
Chest.
From there, what did you see happen?
My sister walked to her car and she fired the gun at my sister.
Where was your sister when she fired the car?
Behind her car.
Sister was behind the car. and she- Did you see when she fired the car? How was she pointing? Rephrase. When you saw Miss Sherd firing the gun, how was she pointing it at your sister? Could you describe that a little bit better? A little more detail. Was your sister
So
behind
she
the
was
car?
pointing it straight with two
My
hands?
sister, like I'm telling my leg. I didn't tell her how mean you are. Okay. I mean, yeah.
So you had testified, I believe I heard you say she was behind the car. Did I mishear you?
No. Talk about when she injured her, my sister was in front of her from me. And she walked away to her car. When she walked away to her car, that's when she fired the gun at her.
Okay, so when the gun was fired, where was your sister in relation to Miss Sherd?
At the same spot.
So the same spot would be,
Behind the car.
okay, was the car in between her and Miss Sherd? Are they both behind
She
the
was
car?
in the lawn. It was in the lawn. Still by my sister car hitting her car. They both are in each other's car now. They both are in each other's car.
Let me approach her on it.
You may.
I'm gonna sort of walk him through. So let's say, could you draw basically a square on this piece of paper indicating where the yard is? Thank you. And could you put a C where my shirt card was? Why don't you put an R on that?
Car. Somebody else came with her. Sister, how's your year? What she was getting. My sister car is really awesome. Her driver.
You mark and ask what your sister's car was.
Yes.
Are there any other cars in this area at this time?
You know, which other people trying to get through, trying to get past, but she stopped.
So the S is your sister's car, C is Miss Sherrod's car, the X is a third party's car. Did you mark a circle on there where Miss Sherrod was when she fired the gun?
See like a little bit of this space area?
Yeah.
That's like this one. She was. My sister. Because this is other cars.
Where was your sister?
In the street.
I can have you both raise your voice because I can't hear you, the party.
So your sister was, could you put an X through that circle where your sister was?
In the street with the car.
So if I'm looking at that, your sister was not, there was no car in between your sister and Miss Sherrod, or was it? There was not a car in between them?
I was between my.
So there's just open space.
Yeah, yeah,
Okay.
yeah, open space.
Yeah, have that back.
Judge, I can't hear.
Can't hear which one, can't you hear? Mr. Wist, you got to speak up.
Oh, sorry, Your Honor. So that would be- Those are the two people. That's the house. That's the car. That's not the car. That would be, those are people. Circle would be the defect. Sure. The circle with the X is, that's circle with an X supposed to be. Yeah, that would be. No, that would be.
Oh, okay.
And this X is the third party's car. C is the defendant's car. S is Miss Metro's. Square is the house.
Closer to the house. In the street. This is the car park, the street, in the street.
Basically. Understanding, I've got it. Just gonna go through that.
Yeah.
Okay. Your Honor, at this time, I'd like to move to admit. It's just been.
The drawing?
Yes, People's Exhibit A. Would you like me to get it marked?
I'll have Wendy mark it. All right, so there's a motion to admit what the witnesses indicated and the discussion between the attorneys, which will be marked as People's Exhibit 1, which is the drawing that was being referred to by the witness that he just drew. And then Mr. Silverthorne, you're going to cross-examine on the exhibit. All right, so let's have that marked as People's Exhibit 1. We'll stop talking so you can mark it. All right. So without objection, People's Exhibit 1 is admitted.
Correct.
All right, Mr.
I'll
Wisty.
bud here and cross.
All right, Mr. Wisty, you may proceed.
Thank you. Just one further question regarding this photo. So just to clear the drawing, to clarify, the circle with the X where to mark through, that would be your sister. Okay. This is your physical your sister. Could you just, yeah. Just if you just want to point to that, I don't want you to write on it. It's already been permitted. May the record reflect as pointing to what's been marked as the S on the exhibit.
Okay, so the S on the exhibit is his sister.
C is her car. X is the second person that she came with.
So the C is her car, who is her? The X next to the C, just to the right of it would be a third party's vehicle. So the small X to the furthest right on the top is your sister.
It's the car.
There's two X's right there, just for clarification. There's two X's right next to each other. One's to the left, one's to the right.
I know, yeah, this one, car.
Left is the car, the right is the, yes, and the circle is the defendant. And about how far, this is where they were positioned when the defendant fired the gun. About how far away were they when that happened?
Same,
Say it again.
like the same.
The
10
same
to
as
12
about
feet?
5 to
Or- I think you said 6 feet initially.
Okay, so about how far I was from you when I had the chair. All right.
So let the record reflect 10 to 12 feet.
Just one more question, and how was that gun pointed? Right before that. Straight and what, towards who? No further questions, Your Honor.
Cross-examination, Mr. Silverthorne.
You indicated that you videotaped the interaction between your sister and Ms. Sheard. Is that correct?
Is that a yes?
Yes, sir.
Okay.
And I think you had testified that you had seen Ms. Sheard's car pull up. Is that correct? Did you start videotaping at that point?
At first, I was just showing, the person I was on the phone with, I didn't think it was gonna be major, I didn't think.
Did you recall Ms. Sheard's car or the second car move at any point during this interaction?
And like what I'm saying is like, he came, jumped out the car, went to my screen.
Did your video capture where the cars are parked? Meaning if I were, okay. And that location never changed, is that until those cars left, right?
Yeah,
Okay, good. And your video is video only, not audio, right? You can't hear voices, right? Were you able to hear any of the discussion of the yelling? Okay, so you can't report anybody saying anything, correct?
I could hear it, but nobody else can hear no video.
Okay. Oh, you could hear it?
Yeah,
Okay.
yeah.
Did you hear Ms. Sheard say anything?
Yeah, yes, I could.
Okay, what did you hear Ms. Sheard say?
Just talking crazy, just talking like, I don't know, like they was just talking like how you arguing, like.
Okay, so what you heard was just general arguing.
Yeah.
You can't pick out any specific conversations, is that correct? You didn't hear Ms. Sheard indicate that she was gonna kill your sister, did you?
Like she was like, you keep walking up to me, yeah, like. Maybe like this.
There might have been something like
She
something.
was standing there. Yeah, she was standing there.
Are you saying you remember it or it could have happened?
I remember it.
Did you tell the police that?
No, I didn't tell him. When that came, my general was just,
How soon did the police come?
10, 13, 14 years later.
Okay, so it was real fresh in your mind at that time, right?
Yeah.
Okay.
A little bit.
At what point did you start recording?
Like 30 seconds. No, 15 seconds after she came.
Okay. And it caught both your sister and banging each other's cars with bats, correct? So you got all of that,
Yes, sir.
and you got the waving of the gun, correct?
Yes, sir.
And you got the shooting, is that correct?
Yes, sir.
Did you see where the bullet went?
Yeah, it's a picture of the book. They got it.
No, did you see where it went? Did it hit a vehicle? Did it hit a tree, break a window, go into the ground?
I just seen it. So I just seen the picture of the bullet in glass. I didn't
Okay,
see it.
picture, okay.
But I
and-
know she was trying to hang from my sister.
And
Oh, I know.
after the shooting, your video would capture that your sister and Ms. Sheard continued beating at each other's cars, correct? All right, your sister didn't run into the house or anything? Or she- Okay. The shooting occurred after both women had bats, correct? You're close to your sister?
It's not too much though.
Okay, did it occur to you to go out and try to help her? What, did you think she didn't need help?
So they come inside.
Okay. Did she come inside? Okay.
How you?
When did the video stop?
When she walked that car,
Okay,
she pulled off.
and so when they pulled off, so you have your video captures about 30 seconds after Ms. Sheard arrived, correct?
50 seconds after she.
50,
15.
15 seconds. Oh, almost immediately as she arrived, correct?
Yeah, that's what I'm saying.
And it ends when all the fighting and glass breaking and shooting are done and they're, and Ms. Sheard is in the other vehicle are pulling off, correct? Okay,
You captured her, got her again.
all right. From what vantage point did you take this video? What I mean is, where were you? Were you in one place where was your phone moving?
I was on the porch.
You were on the porch the whole time?
Yeah,
Just an outside porch?
yes.
Okay, so you had an unimpeded view, correct?
Yeah, I seen
Okay, and you were just, the porch was within 10, 15 feet of where this was going on, correct? Okay,
Ken, yes, sir.
it. Yes, sir.
Thank
all
you.
right. So would you agree that what you've recorded would probably be the best evidence because it's exact?
That audio, yes. But it's videos in the end, you can see everything.
You said the video. Didn't you indicate that there isn't audio?
Yeah, that's what I'm saying. I said, if it was audio, if it were audio, not that there is, if it were, there's a video.
Okay. But you're saying it, but it would show you what you're seeing, just not what you're hearing. Is that correct? That's fine. Thank you, sir.
Any redirect?
Yes, just briefly, Your Honor. Mr. Mitchell, you testified that you did hear certain threats being made on, the defense attorney was talking to you. What were the specific words you heard? One of them was I heard. My sister was to keep walking at church and hit her with the baseball bat that she was gonna shoot him. So you heard, who is she in that situation? Who is she? The lady? Yeah, who said that, just for clarification? Defendant. Did you hear her say anything else specifically? I didn't hear her, but I know for sure she said something, but I didn't hear. Because I'm telling you, my adrenaline rushing, I'm not really good about it. So you would have heard General arguing. Yeah. As you recall, you specifically heard one statement. Yeah. And what was that statement? It was the, if you keep walking up to me with that baseball, I'm gonna shoot you. No further questions, Your Honor.
Mr. Silverthorne, may this witness be excused?
If I have a question, because
Sure.
You didn't report hearing any statements to the police at the time, did you? Pardon? You weren't thinking about it? Your sister had been shot at 15 minutes earlier, is that correct? And you weren't thinking about it?
Oh, she said? No, it's a word.
Is there a reason that only today you're remembering that Ms. Sheard made that statement? Please, I ask the questions. I ask the questions, and when I'm done, you can say you don't understand, ask me to rephrase it. Only today are you, for the first time, indicating that you heard Ms. Sheard say, if you keep coming at me, I'm going to shoot you, correct? Thank you.
Then yes.
Well, it's actually the same question you asked me. They did all the bring it up.
All right, Mr. Whiskey, any further questions?
Yes, Your Honor. You're saying that, did the police ask you what you said? When the police interviewed you, they asked you if you offended made these statements. I had a 10-second talk with them. They didn't talk to me like I was wrong. They asked me what car was she in, what gun did she have, stuff that I didn't know. I didn't know nothing about her car, what gun she had. I didn't know she shot at my sister. They didn't ask me literally nothing else. They asked me what car and that, and I said I don't want to talk on my mind. They part. I go back in the house. I have a new question now. I never got asked these questions. That was just no further questions.
All right. May this witness be excused, Mr. Silverthorne?
Yes, Your Honor.
Mr. Whiskey?
Yes, Your Honor.
All right, this witness is excused. Mr. Whiskey, any further proofs?
No, Your Honor.
Do the people rest?
Yes, Your Honor.
Any proofs today, Mr. Silverthorne?
No, Your Honor.
All right. Mr. Whiskey, motion?
Yes, Your Honor, I would move to bind over on count 1, as well as count 2 and an added count 3 of felonious assault. What we heard here is testimony that essentially the defendant brought a gun to a back fight. It escalated beyond any point that I think it can be considered reasonable self-defense. It's also occurring at the defendant's home. The testimony also occurring at the victim's home. The testimony is that the defendant came to the victim's home and initiated this. Ultimately, what we have is testimony from Destiny Mitchell that a gun was fired. It was being held roughly at her chest level, and the gun was fired one time. I think from that, on a probable cause standard, that's enough to infer that there was intent to do great bodily harm less than murder. If you're firing a gun at somebody from that close range in that direction, that's enough to infer that there was intent to do great bodily harm. That would be striking them with a bullet fired out of a firearm. And I think beyond that, there would be enough here to show that there's intent to in fact commit murder at this point. That being that she fired a gun at somebody, the natural consequence of that would be that it would be the result of murder, Your Honor. So I believe the intent for count 1 is. Matt, I apologize, I misspoke there, but I believe that the firing of a gun from somebody from that range is enough for a probable cause level for intent to commit murder. The weapons carrying concealed, we heard testimony that she had that gun in the vehicle and then later in a bag, she removed it. I believe those are met. And lastly, on the added count of felonious assault, I believe that we've established that by pointing of the gun at somebody, a gun being a dangerous weapon, the assaulted element, so met, Your Honor. So for those reasons, the people would move to bind over this morning, and I do have the pack code for the felonious assault, if the court would like that at this time.
All right, what is the back, just what's that back code? The 804? 802.
And that's 4 years and or $2,000, Your Honor.
All right. Response to the motion for bind over.
Primarily opposing the bind over motion on count 1. So, the brother actually supplied that there was a statement, I don't know if it's true or not, but that if you keep moving, I'll shoot at you. Apparently a shot or two then was fired, and the parties continued their engagement. So one of two things happened. She could have intended to hit her, or she could have intended, to warn her back. And I think that even on a probable cause standard, if someone is not moved back by that shot, and in fact continues while you're with a gun, and more shots are not fired that could have been fired, that even a general intent to commit murder, and of course this is a specific intent, and it could also be fulfilled by providing a situation in which there's a high risk of death occurs, is just simply not present in this case. And I'm going to oppose I think that maybe assault to do great bodily harm, yes. Felonious assault, certainly, again, and that's not conceding guilt in that, but just based upon the standard would be possible. But I don't see an assault with intent to commit murder here, Your Honor.
Thank you. Any response to the objection to bind over?
I would just say on the assault with intent to murder, we have testimony that she fired a gun in close range. I think that's common knowledge, and natural consequence of that can be tested. She just happened the best.
All right. So the standard is probable cause being the second lowest standard in criminal law, reasonable suspicion being the lowest standard. That's the standard for this preliminary examination. Court finds that the identification was met by both witnesses, and both witnesses testified, Destiny Mitchell and Jonathan Mitchell. And then we had one exhibit in which really a clarification exhibit concerning Jonathan Mitchell and some of the proximity and where everybody was standing in regards to the scene. The scene is 407 West Oakland, City of Lansing, Ingham County. That is on the corner of Oakland and Walnut. and the date is October 5th, 2022. So that accounts for location, venue, ID, and date. The venue being 54A City of Lansing, Ingham County. So as to the offense, there was plenty of testimony that indicated that this started out as a altercation concerning bats, and at some point in time, it was escalated to a bat versus a gun, and a gun was fired from the defendant Sharika Sherrod at Destiny Mitchell. The approximation of the proximity of the two parties appears to be, from Destiny Mitchell's testimony, 10 to 12 feet. From Jonathan Mitchell's testimony, was someplace over 6 to 12 feet, depending on he first testified to 6, and then he said over 10 to 12. But there was an assault upon Destiny Mitchell with the intent to commit the crime of murder based on the probable cause standard. This was a gunshot fired at 10 to 12 feet away within proximity. There was a lot of testimony, including testimony from Ms. Mitchell, that it was pointed at the shoulder or head length, which is point blank range. There was some cross-examination as to whether it was pointed at the ground, and the witness was pretty adamant that it was pointed at the torso or head at point blank range. Jonathan Mitchell indicated it was pointed at the chest. I believe that that's probable cause to believe that the crime of assault upon Destiny Mitchell with intent to commit the crime of murder at a probable cause standard has been met at count 1. Count 2 is a weapons offense in which Ms. Sherrod shared, the defendant, did come out of her vehicle with the gun and then go back into the vehicle with the gun. So did carry a dangerous weapon, the handgun that was the source of the firing, whether concealed or otherwise in a vehicle operated or occupied by said defendant. That the testimony is that the defendant was operating the vehicle, a silver SUV. That's contrary to the 5-year felony and or $2,500. And then finally, the third count, which is felonious assault, which is really a lesser of the assault murder, is that the defendant was pointing a firearm, which is a dangerous weapon, and did shoot the firearm, maybe not with the intent to murder, but with the intent to put fear in the individual, pursuant to in violation of 750.802, which is the last added count for bind over today, which is a 4-year felony and or $2,000. I find probable cause evidence to find that the people have met their burden on counts 1, 2, and 3, and that the identity of the individual who committed each one of the 3 felonies. There are now at circuit court, there are matters that go to beyond a reasonable doubt level. Their credibility matters, but at district court, at the probable cause level, I believe the people have met their burden of proof on counts 1, 2, and the added count 3, and we'll bind this case over to circuit court. The circuit court arraignment will be given by the circuit court as to that date. I will indicate that the examination was held on today's date and sign the bind over. Anything else concerning docket 2202-765, Mr. Wisty?
No, Your Honor.
Anything, Mr. Silverthorne?
No, Your Honor.
All right, Ms. Sheard, please keep in contact with your attorney, Mr. Silverthorne, in circuit court for any time of dates in regards to this matter and representation, okay? All right, so that's all for the record, docket 2202-765.
Never made it for today.
All right, we're on the record in docket 22-02594 and 22-02594. That is a show cause. There's a show cause for fail to appear. This is just a confirmation of a medical condition.
And there's gonna be a plea today, so I'd ask that the court withdraw the show cause and we just move to the plea.
Okay, Mr. Wisty?
I would leave that in the court's discretion. This was a case where we had Miss Allen, missing due to COVID. I believe the direction was to bring proof at this hearing. For what it's worth, she did provide notice to the defense attorney long enough for me to call off the witnesses and the other matters. So I would leave that in the court's discretion.
The court's satisfied that there's no need to show cause today, so I'll dismiss the show cause in regards to, I think that was only to verify that the medical condition was preventing the defendant from appearing to court. I'm satisfied in that regard. So let's move on to the resolution of the case. Mr. Wisty, how is the case being resolved today?
Your Honor, we've reached a resolution where the defendant will plead no contest to an added count 3. This will be larceny by conversion, $200 to $1,000, 1 year and or $2,000 or 3 times value. To impose the value, defendant must admit the amount or it must be determined by trier of fact.
So it's 1,000 to, what's the 1,000 to 3,000? 1,000 to 2,000?
200 to 1,000.
200 to 1,000, okay. $200 to 1,000, and what are the ultimate penalty for larceny by conversion?
1 year and or $2,000 or fine of 3 times the value. To impose 3 times the value, it must be determined. She must either admit the amount or it must be determined by the trial of fact.
And what's the PAC code for that?
Give me 1 moment, Your Honor.
Your Honor, may I approach with a signed advice of rights form?
Sure. Thank you, Mr. Nichols.
PAC code is 750.362. Apologize, Your Honor. This is my fault. I wrote down everything but the PAC code in my note. Its PAC code is 750.362 4A.
4A.
Yes. In exchange for 3, the remaining counts 1 and 2 will be dismissed. We also have a Killebrew agreement of no initial jail, and there is agreement that Miss Allen will pay restitution to be determined at a later restitution hearing. She will go on a payment plan to pay that pending the results of the hearing.
Right.
We do have a police report that I can present to the court for the basis. I don't know, basis is civil liability.
Okay.
And I have a police report for the factual basis.
So I'll restate that. The plea agreement, as I understand it, and then Mr. Nickel, you can correct me if I've gotten anything wrong. Basis for no contest. So it's my understanding that the defendant's going to be pleading no contest to larceny by the added count 3 of larceny by conversion, which is punishable by 200 to which is 200 larceny by conversion, $200 to $1,000, punishable by 1 year and or $2,000 in violation of 750.362 parents 4 parents A. There's a Killebrew agreement of no upfront jail. The rest of restitution is to be determined at a later hearing in regards, and payment plan can be set up in regards to restitution. This is a no contest plea, and civil liability is the basis for the no contest plea. Have I missed anything, Mr. Nichols?
No, Your Honor, that is a full and accurate statement of the plea offer that's been.
All right. May I inquire of your client of their advice and rights concerning the no contest plea?
Yeah.
So ma'am, you've already signed an advice of rights concerning this no contest plea.
Yes,
And we're gonna take the factual basis in regard to a police report that I'm assuming is being
Yes,
sent.
Your Honor.
All right. You understand if I accept your no contest plea, that you'll be giving up certain rights that you would have in regards to contesting these charges. And you understand that you will not be having a trial of any kind. We'll treat the no contest plea as a guilty plea. Do you understand that?
yes,
And my understanding is it's a no contest plea for civil liability purposes. Do you understand that, ma'am?
yes, Your
All
Honor.
right. So you would have the following rights. You've already signed your advice of rights. I'll walk you through some of those right now, but you've already signed your advice of rights and I'll add it to the file. You have the right to be tried by a jury today. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by Public Defender Scott Nickel, and he would be available to contest any charges and cross-examine any witnesses. You have the right to have the court order any witnesses on your behalf testify at trial. You have the right to remain silent. You have the right not to have that silence used against you, and you have the right to testify at trial if you choose to testify. So if your plea of no contest is accepted, you'll be indicating that you're not relying on anything except what the plea agreement is. There were no other conditions or anything under duress that you've made. You're pleading no contest because you want to resolve this case in this manner.
Yes, Your
All
Honor.
right. So I'm going to, and you'd be giving up the right to trial in this, so you couldn't appeal any trial rights if you plead no contest today. Do you understand that?
Yeah, I understand.
All right. So for the factual basis, civil liability being the purpose, I will indicate that I'm looking at case number, the report numbers 205191141, and that is my understanding. Both parties have agreed that I will take the factual basis from that document. Is that correct?
Correct, Your Honor.
Correct, Your Honor.
Okay. So we will go to that over the course of time. Right, so this is a fairly lengthy police report, but my understanding on the factual basis is that the defendant entered into a purchase agreement on a 2013 Chevy Malibu, that payments had stopped approximately 6-7 months after the financing, and that a signature was forged on the title, which was to transfer it into the defendant's name. The defendant issued the vehicle's title to the insurance company and was then paid for the vehicle, and kept the money from the insurance company concerning the fraudulent title of the vehicle. And the restitution somewhat is still to be determined.
Correct.
And so I believe that would be the factual basis for the charge of larceny by conversion, $1,000 or more, but less than $20,000, which would suffice for the $1,000. I'm sorry.
200
to 1,000.
Right. But the factual basis that I'm taking would be for the count one. And then I think I easily can take it as to count three for 200 to 1,000. Okay.
Understood, Your Honor.
Yeah. So I think the factual basis is apparent that there was a larceny by conversion for 200 to 1,000 based on the factual basis for the higher count, and therefore the no contest is the factual basis for the no contest has been found in regards to possessing money from that was meant for either the vehicle, person responsible vehicle, or the insurance company, I should say the retailer, and kept it, and a forged document was sent in regards to the title of that vehicle, so the money was converted to the defendant's use. I'm going to, so that understanding, any reaction or any statement on the factual basis coming from the police report for larceny by conversion in this matter. And that's the police report that was previously indicated. Mr. Wisty,
No, Your Honor.
anything, Mr. Nickel, on the
Nothing.
factual basis?
Nothing further on the factual basis.
All right, thank you. I'm going to refer this to probation, of course. To probation. And I know that the defendant has another matter to get to, a medical matter to get to, but since we are meeting on, so we'll set it Tuesday at 4. So I'm gonna, you're to report to probation by Tuesday at 4.
Do I come here or do I call them?
I would come here if I were
Okay.
you.
I
Okay.
gotta arrange a ride. I live in Diamonddale, so.
All right.
kind of-
So I would come here and do the report Tuesday by 4. It's the 5th floor here. And that way you get it all done at once and you don't get into this calling back and forth thing.
Okay,
Because once you get it done, it's all set and then they can do the pre-sentence report. Okay.
okay,
So, and I'm gonna give you Tuesday by 4. It's next Tuesday. So
Okay.
you should have plenty of time to get the report to get transportation issues. So we'll refer to probation Tuesday at 4 for pre-sentence. And sentencing date in this matter,
January 31st at 1:30.
January 31st at 1:30 will be the date of sentencing. And then they will make a determination if they are able to concerning restitution. And if not,
What's going on, Your Honor, is that there's a dispute of the restitution.
All right.
now. So I think a hearing will be necessary unless the defense would be willing to agree to what it's about.
at this point in time, it's contested.
Yes,
Okay.
and we, Mr. Wisty and I can talk to see if we come to an agreement. If
All right.
we can conduct a hearing.
All right, so right now we have it set at January 31st at 1:30. If that turns into a sentencing, into a restitution hearing, just let us know, okay?
Okay.
Absolutely.
All right, anything else for the record in docket 22-02594, Mr. Wisty?
No, Your Honor.
Anything, Mr. Nickel?
No, Your Honor.
All right, Miss Allen, we'll see you back here on January 31st at 1:30, okay?
Thank you, Your Honor.
Okay.
Thanks, Mr. Nichols.
Not a problem.
Here's your advice of rights, Mr. Rice. And Mr. Wisty, here's your no contest rights.
Thank you, Your Honor.
Yeah.
on the record in docket 22-01268. That is people of the state of Michigan versus Christopher Fisher. Will the parties please introduce themselves to the record?
Jake Wisty on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Fisher.
And sir, you are Christopher Fisher?
Yes, Your Honor.
All right. This is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, we've reached a resolution where Mr. Fisher will accept the offer that has been made. That would be plead guilty to an added, it would be a no contest plea this morning. My understanding from defense is the reason is lack of memory. This occurred several months ago and also potential of civil liability. But it would be no contest plea to an added count 2. That is B&E in a vehicle less than 200. Pack code is 750.356A2A. And that is 93 days and or $500. And in exchange for that, the people will dismiss count 1.
Right, my understanding, that's B&E in motor vehicle, 200 to 1,000, was that it?
Less than 200.
Okay, less than 200. All right, Mr. Nickel, I'll restate my understanding of the plea agreement, and then you can correct me if there's anything I missed. My understanding is there's going to be an added count 2 of B&E in motor vehicle less than $200 pursuant to Michigan law 750.356A2A, punishable by 93 days and or $500 with a plea to count that added count 2. Count 1 is to be dismissed. This is a no contest plea because of lack of memory and potential for civil liability. Is that a fair statement?
That is, Your Honor.
Okay. May I inquire of your client of their advice of rights?
You may.
Okay. Mr. Fisher, you've indicated in an advice of rights that you signed that you understand these rights, but I'm going to walk you through them anyway. All right. And my understanding is you're pleading no contest today. There's a maximum penalty for the misdemeanor that you are going to be pleading no contest to of 93 days and or $500. My understanding the no contest plea is for lack of memory of the event and potential civil liability. You will be giving up the following rights if you plead no contest. All right. So I'll walk through those rights with you. All right, sir. You have the right, you would be giving up the right to trial, to be tried by a jury, to be presumed innocent until be proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses against you. You, of course, are represented by Public Defender Scott Nickel, and he would have the opportunity to cross-examine or contest any charges at trial in your defense. Do you understand that, sir? Sure. You'd have the right to have the court order any witnesses appear in your defense and testify. You to remain silent during the trial and not to have that silence used against you in a court of law. You'd have the right to testify at trial if you choose to testify. Of course, if you plead no contest today, you'd be giving up the right to indicate that this no contest plea was based on any threats or duress other than the plea agreement that we've talked about. Do you understand that, sir? Sure. And you'd also be giving up the right to appeal from a trial because we wouldn't have a trial, so there'd be no issues of appeal. You are pleading no contest, and I will be looking at the no contest plea in order to resolve the matter. Do you understand that, sir? All right. Is there a police report concerning the no contest plea, Mr. Wisty?
Yes, Your Honor, from the approach.
Yes. So it's my understanding I'll be taking the factual basis from a no contest for the no contest plea from a stipulated report as to it's case number 225-1903-267, Lansing Police Department police report. Is that a fair statement, Mr. Wisty?
Yes, Your Honor.
Mr. Nickel, that's your understanding?
Yes, Your Honor.
All right. So the attention will be brought that on April 12th at the location of 1514 East Michigan Avenue, City of Lansing, Ingham County, that a catalytic converter was stolen from a car in the city of Lansing, specifically on Michigan Avenue in the city of Lansing. It was taken off a 2018 Honda HRV. And that identification of the defendant, Mr. Spalding, was made pursuant to surveillance footage, which was compared with surveillance footage and surveillance photos in which the defendant was identified as the individual who was responsible for the theft. I think that would indicate for the record, the catalytic converter was worth approximately $1,000 per the police report, but I think that meets as a factual basis for the B&E of motor vehicle less than $200, the misdemeanor factual basis for the no contest plea. Any questions concerning location, offense, venue, ID, or date of the factual basis concerning the no contest plea, Mr. Wisty?
No, Your Honor.
Anything, Mr. Nickel?
No, Your Honor.
All right. So I find that it's a valid factual basis for the no contest plea. People will move to dismiss count 1 at this time. And we will send this to probation. So I'll refer to probation for Tuesday of next week, which will be Tuesday, the 29th by 4. So Mr. Fisher, you should report to probation on the 5th floor by Tuesday at 4. They'll prepare a report for me. That'll come in, that'll be looked at date of sentencing, and date of sentencing's out a little bit right now. So the date of sentencing will be
January 31st at 1:30.
January 31st at 1:30. So if you're able to do that today, fine, but if you have till Tuesday at 4 to get them and get all the information they need for the report, okay? Mr. Wisty, anything in regards to docket 22-01268 from the people?
No, Your Honor.
Anything, Mr. Nickel?
No, Your Honor.
All right. With that understanding, that's all for the record in this file. We'll see you again on January 31st, Mr. Fisher. Okay, thank you.
Thank you. And then Ms. Burchett.
All right. And here's the report for Mr. Burchett. We're on the record in docket 22-02598. People of the state of Michigan versus Ashley Burchett. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Ms. Burchett.
And ma'am, you are Ashley Burchett?
Yes.
Okay. This is the time set for preliminary examination in the matter. Mr. Wisty, how we proceed?
Your Honor, my understanding, excuse me, the defendant.
Sure.
Thank you, Your Honor.
You're welcome.
We've reached an agreement where the defendant will plead guilty to an added count 2 or no contest. To added count 2, a larceny. That would be the larceny 200 to 1,000, 750.3564A, 1 year and or $2,000, or 3 times the value. To impose 3 times the value, the defendant must admit the amount, or it must be determined by the trier of fact at the time of trial. There's also an agreement to a restitution hearing to be held, I believe, at the time of sentencing would be the court's practice. There is a dispute about the amount of restitution owed here. And in exchange for that, plea count 1 would be dismissed.
And the the no contest is for civil liability purposes.
Yes, Your Honor.
All right, Mr. Nickel, I'll restate that plea agreement as I understand it, and you can indicate if I've missed anything. My understanding is the defendant is going to plead no contest to an added count 2 of larceny 200 to 1,000 with a plea to that pursuant to 750.3564A, a 1 year and or $2,000 with a plea to that amended count 2. Count 1 is to be dismissed. Restitution, so count 1 will be dismissed. And restitution will be determined at sentencing. Is that an accurate statement of the plea of the no contest plea resolution?
Yes, Your Honor.
All right. And ma'am, you've signed, and so may I inquire your client of their advice of rights concerning the no contest plea?
Yes, Your Honor.
So Ms. Burchett, you've signed an advice of rights in this matter. I'll add that to the file. My understanding is you're pleading no contest today, and I will walk you through some of the rights that you are going to waive in order to plead no contest. All right. You're going to be pleading to count 2. The maximum penalty in regard to the misdemeanor you'll be pleading to, larceny 200 to 1,000, is a 1 year and or $2,000. Do you understand that, ma'am? Okay. If you are able, your plea of no contest is accepted, you'll be giving up the following trial rights that you'll have, and I'll walk you through those. You have the right to trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by public defender Scott Nickel. He would contest any charges or cross-examine any witnesses brought at trial in your defense. Do you understand that, ma'am?
Yes, Your Honor.
You have the right to have the court order any witnesses that you may have for defense that appear at trial. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Simply said, if your plea of no contest is accepted, you'll be giving up any right to indicate that this was done under anything else but the plea agreement, any duress or coercion of any way. Do you understand that, ma'am? All right. You will not have a trial in this matter if you plead no contest, so you'll be giving up any appellate rights concerning the trial. Do you understand that? So my understanding, it's your intention to plead no contest today and to waive those rights to a trial. All right. What will be using as the factual basis for the no contest plea?
That would be the police report, Your Honor, and I will hand it to you now.
All right. So my understanding pursuant to stipulation of counsel, the factual basis for the no contest plea, which is based on potential for civil liability, would be the report number of 225-190-2502. That is a report for the city of Lansing. And my understanding pursuant to stipulation, that is what's going to be used as the basis for the no contest plea. Is that correct, Mr. Wisty?
Yes, Your Honor.
And Mr. Nickel?
Yes, Your Honor.
All right. All right, so in regards to the factual basis, which could be done under the larger count of count 1, but is a plea to the larceny 200 to 1,000, which is the amended count 2. It appears that on March 2nd, 2022, at the offense location of 3408, well, that's the Inverary Road address. And this is the uttering and publishing. So that is the correct address. Withdrawals from several locations. So at 3408 Inverary Road, City of Lansing, that it appears that the person identified as Ashley Burchett did pass a check for the amount of $638.29 that check that was not hers, was known to be somebody else's. She did not have authority to pass the check and therefore took money in regards to money that was not hers. That starts with the uttering and publishing count of count one. And the larceny would be the fraudulent taking of the money in regards to converting it to their own use under a general larceny statute, which would be, I think the check was made out for $638.29. $600 of that was withdrew, and then the check bounced, and it appears that the check, that there was no authorization to apply for that process or make that transaction. Anything else concerning the factual basis, concerning location, offense, venue, and ID or date for the factual basis for the larceny 200 to 1,000, Mr. Wisty?
Yes, sir. I believe it would be better supported by the fact that the defendant used a debit card by a Sarah, and I apologize.
Pellavanglo?
Thank you, Your
Yeah.
Honor. Without her permission, withdrew $600 there. To be frank, there are some issues with the check charge as is, so a factual basis, which I believe is on the police report.
All right.
That she used her card and took money from.
All
the
right,
account.
so that would be on a different, well, would that be on the same date? It
Yes.
appears same date,
Yes.
yeah. So the debit card that was taken by the defendant, Ashley Burchett, belonged to a victim, Sarah Pellavanglo, and that would constitute the larceny 200 to 1,000.
Yes, using her card to take the money. From
All
the
right.
account.
And I also find a factual basis concerning the police report for the larceny 200 to 1,000 for the unauthorized taking of the debit card from the victim. Anything in regards to that factual basis, Mr. Wisty?
No, Your Honor.
Anything, Mr. Nickel, as to the second factual basis for larceny of 200,000?
No, Your Honor.
Large 200 to 1,000, $200 to 1,000. All right, with that, I find a factual basis for the no contest plea to be accurate. And we will refer this to probation because we have for various matters, but so this is referred to probation by Tuesday at 4. So if you can do it today, that's great, but you have till Tuesday at 4 to go, and they'll provide them with any information, and they'll prepare a pre-sentence report for the court to make a determination. Restitution is still out in this case, so there'll be the part of sentencing will be a determination of restitution. Is that my understanding? Mr. Wisty?
Yes, yeah, me and restitution. Sorry.
Determination at restitution. Restitution at sentencing and a sentencing date.
The sentencing date and restitution hearing will be on January 31st at 1:30.
January 31st at 1:30. So ma'am, please report to probation by Tuesday at 4 on the 5th floor of the building. They'll prepare a report and we'll determine your sentencing status and the restitution status by January 31st at 1:30. Okay, ma'am?
Yes, Your Honor.
All right. Anything else for the record on docket 22-02598, Mr. Wisty?
No, Your Honor.
Anything, Mr. Nickel?
No, Your Honor.
All right, thank you. That's all for the record in that file. Thank you.
I'm trying to write it down there since